we're getting started. Hello, everybody. Welcome. My name is Tyler Welsh, and I just want to say thank you for joining us for today's webinar. We are very excited to have you join us, and we are very excited to have our speakers, Cindy and Shannon, here with us today. Before we get started, I just want to go over a couple housekeeping things. First off, I want to thank you in advance for any potential issues that we may have. Knock on wood, hopefully we don't have any. But if you do experience any issues, we just want to say that you can visit support.zoom.us. And lastly, before we get started, you will notice at the bottom of your screen, there is a Q&A box. This is an interactive webinar, so you are free to ask questions at any time during the presentation or after the presentation. We are saving some time towards the end for our speakers to address any questions that you have. So you can punch those questions into the Q&A box and we will address them. Hopefully we can get through as many as we can get through. If there are any left over, we'll try to answer them offline for you all. But with that being said, I don't want to take too much time taking away from our presentation over here. So that being said, I will pass things over to our speakers, Shannon and Cindy. Welcome and thank you both for being here today.
Thank you, Tyler. Hi, I'm Shannon Kristoff. I'm the Managing Director of Plan Giving for the Schools and Centers at the University of Pittsburgh. Before we begin, I just wanted to give a quick disclaimer. While both Cindy and I were once practicing attorneys and do have legal degrees, today's intended to just simply provide some ideas for your consideration. And our comments and materials that we're presenting today should not be taken nor replace the need for legal advice. It's our hope that the things we discuss today will help your discussions with your attorney and perhaps offer some new ideas as you consider create your legacy. So to start off, let's talk a little bit about what is an estate plan. Estate plan are very important, and what can they do for us? There is a set of legal documents that instruct what will happen to your assets after your death and appoint who will make decisions about your health care and assets during your lifetime. And while we often think of estate plans just controlling our assets after death, it's just as important to put these plans in place that allow others to act on your behalf during your lifetime should you need them to. So there are a few important parts of an estate plan. First off, what's the most common thing that everyone thinks of when thinking about an estate plan would be the last will and testament. So it includes things like who will inherit our treasured belongings, who will sell our home, how do we provide for the people and organizations that are important to us with gifts from our assets. A will or a living trust details what you choose to do with your assets and who will carry those wishes out upon your death. Beneficiary designations are also effective only upon death and name beneficiaries of the asset. So for example, if you own a life insurance policy or retirement account, you're often asked to list who or what organization will receive that asset after you die. These assets are then given to the beneficiary directly from the administering bank or corporation to the beneficiary and do not pass through the will or living trust as part of the estate plan. Next, we have the financial power of attorney, and this is a document that's effective during your lifetime. So let's say you've been involved in an accident, and you'll need a few months of rehabilitation and rest to get back on your feet. Who will pay your bills during this time? If you have a financial power of attorney, this agent can take care of your day-to-day financial needs while you focus on getting well. Without such a document, a bank will not provide confidential information or access to your accounts or anything else. They're legally prohibited from doing that, as you can imagine. It's a privacy concern. So it's very important to have this document in place so that banks know that they're able to give that information to your agent. And finally, your healthcare power of attorney, sometimes also called a living will or advance directive. These important documents would allow you to designate a person who can make healthcare decisions for you if you are not able to communicate your own wishes. And that could be temporarily, again, if you're in a hospitalization situation and you're not able to respond to your own care needs, someone else could act on your behalf. And we'll talk a little bit more about these documents later on as well. Okay, a great question. Do I need an estate plan? Well, I mean, I think it's something everyone has likely asked themselves from time to time. Maybe that's why you joined the call today. Estate planning is very important for everyone. You absolutely do need an estate plan, and everyone on this call may have different needs or considerations, but I can guarantee that we all do need an estate plan. But what we know is that not everyone does actually carry out and execute their own estate plan. So if we look at this statistic that we see here from a caring.com survey, 68% of Americans do not have a will. So that's a significant majority. And this study also went on to say that this number has actually increased in the past year. For the first time since 2020, more Americans do not have a will than in years past. So it's definitely something to keep in mind if you or someone you love hasn't taken the time to create a will. Now may be the time to take action. But why don't people see the need to execute these important plans? Well, I think one thing maybe that some people think that only those with wealth require an estate plan. But the truth is anyone with assets should create a will or living trust. And all people need to designate agents for financial and healthcare decision-making, as we talked about. Others might think they're too young. So maybe you're decades from retirement or long-term care planning, and you think I have plenty of time to put my affairs in order sometime down the road. But you may have minor children or other considerations specific to you that are important to document. So it's very important that you take the time to protect those you love and put plans in place for them. Sometimes cost can be a factor. Many people don't want to pay an attorney. There are many free resources to create wills and other documents. So there can be neighborhood legal clinics, county resources. Here in Pittsburgh, we have the Allegheny County Bar Association. From time to time will have free will clinics. Veterans groups oftentimes offer free will clinics, and there are online providers as well that do not charge a fee, which is certainly better than no estate plan at all. I would highly recommend those if it's cost prohibitive to engage an attorney. However, I think legal fees are often like the cost of a new roof for your home. I mean, you don't want to pay for the roof, as it is an expensive undertaking, but it does protect your home and everything that is in it. So you know that it's the right thing to do and ultimately something that needs to be done. And a good legal plan is tailored to your specific assets, your goals, helps protect you and give you peace of mind that the future will be exactly what you intend and there's no surprises. You worked hard for your assets. It's important to get good legal counsel to protect them and provide for those you love. But the number one reason, and this is also part of this caring.com survey, number one reason was procrastination. So we all do it. I'm certainly not immune to being a procrastinator. It's human nature to put off things that don't seem urgent. But like most things, you will feel better when it's done. So I strongly encourage you to get in touch with your attorney after our presentation today, if you're in that group. All right, so you may also ask yourself, well, what if I don't have a plan? Surely, my assets, something will happen. The law would provide for something to happen to my assets. What happens if there is no will? So that's what we call a matter of intestacy, meaning that there's no executed or valid will of record for the decedent or the person who's passed away. And this is the Pennsylvania statute. So the reason I share this is because some of its provisions might surprise you. This is the Pennsylvania Intestate Descent statute from the PEF code, or the Probate Estates and Fiduciaries Code of Pennsylvania. So if you're not from Pennsylvania, this might just be, it may not be relevant to you, but you should look into what the law of your state might, what it might be should you pass without a will. So the interesting thing about this is most people assume that your spouse would inherit 100% of your assets if you predecease your spouse. But that's not always the case. As we see here, the spouse, when they pass away, if we go to the left side of the screen, says no issue or parent. So issue or children. If you have no children and your parent is deceased, your spouse inherits your entire estate, which is what we would think would happen. However, if we look in the middle column here, it gets a little trickier and a little surprising, I think, where if you have a spouse, but there are children that are also of your spouse, so you and your spouse, those are your children, or if you have no children but a surviving parent, instead of receiving the whole estate, the spouse only receives $30,000 plus 1/2 of the balance. So that's pretty surprising. I think most people would think that no matter what, if I have a spouse, that person's entitled to my estate when I die. But the law of Pennsylvania actually does not promote that disposition of your assets. And then if we're looking at if you have children on the right-hand side here, or issue, one or more who are not issue of the surviving spouse. So say you have children from a previous marriage, that's not your surviving spouse's children, then the spouse receives 1/2 of the estate rather than the middle disposition. And then it goes on to say that if you don't have, if the share of the estate that doesn't go to your surviving spouse could also be split in either per capita or per stirpes, meaning either by the number of the relationship or by the bloodline. So it does get to be a little bit tricky. I just wanted to point this out to show that, some of our assumptions about what may happen to our estate plan after our passing may not be accurate. So that's another reason why it's really important to put your intentions into writing through a will or a living trust so that you can avoid this intestacy statute. All right, so what are the important elements of a will? A will details the amounts that you wish to distribute to your heirs. So this can include provisions for family, friends, and organizations that are important to you. So oftentimes it's charities, religious organizations, maybe your alma mater, maybe other organizations that are important to you, so it's important to think through those things carefully and what might happen to those assets, how you want to designate them in terms of percentages or outright amounts. So say you want to give 25% to one, 25% to another, or do you want to give them a fixed amount? Say I want to give $15,000 to this individual. So there's many different permutations that you can outline within your will based on your choices. A will also names a personal representative. So that's also sometimes called an executor or an executrix, more commonly now known as a personal representative of your will. And that individual has the responsibility to gather information about your assets at the time of your death, pay any creditors or expenses, funeral costs, attorney fees, tax preparation fees, pay the final tax returns, both personal and for the estate, if there's any inheritance tax returns to file as well, and distribute the funds as the will dictates. So this is a really important role, and it's something to consider wisely as you think through who might be appropriate to fill that position. You should always name a successor or a backup personal representative a generation younger than you. So oftentimes what we'll see is that people tend to name, their spouse, which is perfectly acceptable, and maybe their sibling. All of those people are generally within 5 to 10 years of your age. So you can imagine that as you grow older, those people may not be in a place or even survive you in order to act as a personal representative. That's why I always think it's a good idea to have at least one person named as a successor. It could be 2 or 3 levels down within the document that provides you with that knowledge that someone that you trust has been designated, who won't be, who will more than likely outlive you and be able to take that role. And it can also be an attorney if there's language within your will document that allows payment to the personal representative, which most wills will have within it. But as you can imagine, it's important if you're not asking a family or friend to act as executor, that generally other professional executors, such as attorneys or other people who act in those capacities, would require payment in order to act in that role. A really important element of a will for people who have minor children would be to nominate a guardian, to think through that process. And in the unlikely and unfortunate event that you are no longer able to be there for your minor children, who would take that role? Who would you recommend to the court to nominate as a guardian for your minor children? Really important provision. And then also a will, a testamentary trust for tax purposes. So that would include things like minor's trust. So if one of your heirs would inherit assets before the age of 18, what would a trust may be necessary in order to allow someone to manage their assets, or even, beyond a minor's trust, even just a trust to help with the health, education, maintenance, and support of an individual, and particularly important for people who have special needs in order for them to continue their benefits. Oftentimes, assets that they may inherit could make them ineligible for any benefits they're entitled to. So it's really important to create things like special needs trust as well through a will. Okay. And what doesn't a will control? So these assets are assets that pass outside of the will or trust document, generally, often referred to as non-probate assets. And these are the type of assets that would require beneficiary designation. So in addition to those, we also have jointly titled assets. So any account that you may be titled with another person. So say your bank account is with your sibling. Upon your death, if you're both jointly titled as owners, your sibling would inherit that asset. It would not pass through your will. So it's really important when you talk through your estate planning with your attorney to talk about how assets are currently titled and make sure that the structure of your will matches the way the accounts currently would be distributed based on their titling and based on the beneficiary designations that you've already implemented through these different types of assets. So another thing that would pass outside of a will would be real estate, if it's titled as joint tenants with right of survivorship. Anytime you see that joint tenancy within a deed, the other individuals listed on the deed would receive full title to that asset upon your passing, as opposed to it going through the will and being subject to the other terms of your will. Life insurance policies, retirement accounts, pensions, annuities, and social media accounts and email accounts are things that you cannot control through a will. So you may want to consider those things through your estate plan in other ways and make sure that you've listed beneficiaries or contingency plans for those assets upon your death. Okay, a question that we often hear is, do I need a living trust? Well, first off, what is a living trust? So a revocable living trust helps to avoid the probate process. So it's a trust that's set up by a grantor. So that's the individual who owns the assets. And they fund the trust during his or her lifetime with assets titled in the trust. So it works exactly very similar to the way a will would work, except that it's funded during someone's lifetime and it avoids the probate process. So for example, if Jane Smith were to create a trust, her personal checking account that she uses every day would need to be retitled into the Jane Smith Revocable Trust in order for that asset to now be part of the revocable trust. So it does take a little bit of work to get all the assets retitled within the trust's name, but it can provide a lot of, it can be much more efficient upon someone's death to administer an estate that has a living trust, and can be much cheaper at the end of the day in order to do so. So all taxes in a living trust are filed under the grantor social security number, so the person who established the trust, the person who has the assets, and then there's an individual called a trustee who manages those assets. And initially, usually the grantor would be the trustee, but they can also name a spouse or someone else. Similar to the personal representative of a will, the trustee of a trust would have the power and responsibility to act using the assets within the trust. There always should be a successor trustee in case the grantor is not willing or able to act in the future. And one of the benefits of a living trust is that it ensures privacy. Wills are public record, whereas trusts are not. So if privacy is a concern for you or something you would like to have within your estate plan, living trust might be the way to go. If you have properties in multiple states, it can help to avoid the expense of two probates. It can help to expedite the process of transferring those properties if they're titled within a living trust before your death. And oftentimes a living trust will cost more to establish up front because there's more preparation, there's more legal fees associated with establishing a living trust, but it can reduce overall legal fees in comparison to probate costs, which oftentimes are a percent of the estate. So sometimes that can be another consideration as to what's appropriate for you, what will be the best from a cost perspective. Other important documents. The durable financial power of attorney is one of the most crucial documents anyone can have during their lifetime because it allows your agent to act on your behalf. Again, it's something that's important to have because any one of us can need this document at any time, and without it, it can create a lot of stress and concern for our loved ones who may have to, fight a bank or fight a healthcare corporation for bills or things like that because they aren't able to give private information, and it may take some time in order to get that access without a financial durable power of attorney. Sometimes it even requires a guardianship proceeding in order for someone else to have the right to stand in your shoes and act on your behalf. So just by signing a simple document, it can avoid all of those concerns down the road. These documents can take effect immediately or upon a determination of incapacity. Most often we would see people having durable financial powers of attorney that take effect immediately, so that there isn't a need to determine for a doctor to determine incapacity in order for it to take place, simply for ease of administration. But occasionally, if there's no one who's that you feel comfortable with acting on your behalf, unless you're incapacitated, that might be another way you could draft your document. And finally, the advanced directives. So this is your healthcare power of attorney, your living will. These are documents that allow your agent to make medical decisions on your behalf if you cannot communicate your wishes, sometimes also called a healthcare proxy. And again, this can be a temporary thing. This can be, you're in an accident, you're unable to communicate. They'll look to your healthcare power of attorney to make decisions for you about your treatment and care. A living will sometimes is incorporated into the healthcare power of attorney, or it could be a separate document, and it includes specific questions about what types of care in specific circumstances. So it talks about end of life treatment, and it talks about if you're in a persistent vegetative state or other circumstances, and what your wishes would be. And this is a really important document because it helps take the burden away from that healthcare power of attorney, who might not know what you would want in those circumstances. But by giving them this document, they know exactly what you would want, and it helps them make the decision that you would want them to make if they're presented with such a decision. Is it time to update your plan? This is often something I think people ask themselves: when should I do that? The general rule is about every 5 years, or after a significant life event, or I would say a significant tax change. So some of the significant events that could fall into this category would include, did you get married, divorced, were you widowed? Did my heirs change? Did I celebrate a new child or grandchild through birth or adoption? Maybe things have changed to the point where my children don't need the inheritance, and it's time to change allocations to other family members or charities that I would rather support. Did my assets change significantly? That can change some of your planning in terms of taxes. Should I change my personal representative? Is that person no longer able or willing to serve as personal representative? Did I move to a new state? Many of these laws are state dependent. So if you move to a new state, your old last will and testament may not be the most appropriate document for you, given your new state. Did the tax law change? One thing to be aware of is at the end of 2025, some people are looking towards potential changes to the estate tax law. If Congress does not act before the end of 2025, the estate tax could be reduced by half. So currently it's about $13.99 million per person in the United States in terms of avoiding estate and gift tax. If nothing happens if Congress fails to act, it will be reduced to half of that. So that would be $6.995 million per person. So some people are taking action now, knowing that if Congress fails to act, that could be a really significant change. And there are ways to protect your estate from unnecessary taxation if you create certain trusts. So it might be time to talk to your attorney if you think that may apply to you. And finally, did my thoughts about my legacy change? Maybe it's been a while and you're now considering your legacy in a different way. Different things are important to you. And it's time to think more broadly about how you want to be remembered and what institutions you'd like to support through your estate. So an estate plan is really the culmination of a life well lived. When you've worked your entire life to provide the means to benefit your family and those causes important to you, an estate plan can ensure that your wishes are honored and your legacy continues far into the future. Now I'd like to welcome Cindy Caldwell to offer her thoughts on some creative plan giving strategies.
Thank you so much, Shannon. I'm Cindy Caldwell, Assistant Vice Chancellor of Plan Giving and Development for Pitt and UPMC Health Sciences. We really appreciate everyone joining us today. So in Plan Giving, we help individuals create their legacy around their passions, whether that's scholarships, research, endowing a name fund after a loved one. We would be honored to help you figure out what's best for you, meeting both your financial and philanthropic goals. Next slide, please. So we would like to introduce some plan giving strategies that can help reduce income taxes, generate stable income streams, and achieve philanthropic goals. So what are plan gifts? Plan gifts are different from annual gifts. They are flexible strategies used to pursue both charitable and financial goals. There are plan gifts for every stage of life and every level of income. For many, plan giving is the natural extension of their annual giving, and for others, it is the first and last gift to a qualified charitable organization. So one thing plan giving is not is something that is the exclusive domain of the wealthy. Yet a plan gift often allows donors to make the largest gift of their lives, creating the most opportunities for students, faculty, and research. So if you've named the University of Pittsburgh or another charity in your estate plan, please let them know so that they can ensure your gift is used according to your wishes. Notifying the organization will also enable them to plan for the use of your future gift. And if you prefer to remain anonymous, please know that your name and gift can be kept in strict confidence. Next slide, please. So how can plan giving benefit you? Plan gifts can create lifelong income for you and your loved ones, build a legacy, lower taxes, and make the most advantageous use of your assets. Ultimately, making a planned gift offers you the peace of mind that your philanthropic priorities will continue for generations to come. Next slide, please. So again, planned gifts are flexible strategies, which include gifts that cost you nothing today, like a bequest, gifts of strategic assets, like appreciated assets, and gifts that pay you back, like charitable gift annuities. All plan gifts may be directed to support a specific program of your choosing, such as pioneering research, student activities, or a targeted scholarship fund, among others. Now, let's briefly explore some of the strategies. Next slide, please. So gifts that cost you nothing today. Making a gift to a qualified charitable organization in your will or naming them as a beneficiary of your retirement account, life insurance policy, or donor advised fund allows you to help without making any impact on your income today. A donor can specify a dollar amount or a percentage of the estate to be given. And adding a charity as a beneficiary designation of a retirement account or life insurance policy is often as easy as completing a form. We are happy to help with any questions related to that or verbiage. Next slide, please. So Americans over the age of 70 and a half can take advantage of a simple way to benefit their favorite charity while often receiving tax benefits in return. Individuals can give up to $108,000 this year from an IRA directly to a qualified charity without having to pay any income taxes on that money. It's called an IRA charitable rollover or qualified charitable distribution, and the maximum donation amount is indexed every year for inflation, increasing from the original amount set of $100,000. Furthermore, if you are 73 years old or more, you must take a required minimum distribution, an RMD, from your IRA each year. An IRA charitable rollover will fulfill some or all of this requirement without increasing your taxable income. If you have not yet taken your RMD yet this year, your IRA charitable rollover gift to charity can satisfy all or part of that. So next slide, please. So gifts that pay you back. You can create a charitable gift annuity or a CGA by transferring cash or assets directly to a qualified charitable organization. Creating a CGA is easy and offers reliable, fixed, lifelong income at rates that are often better than traditional safe investments. Or you can establish a charitable trust by transferring cash or assets into a trust, and then the trust will make annual payouts. Both gift options generate an immediate tax deduction for you, reduce capital gains tax, and provide an income stream. Today's presentation will focus on CGAs, but please feel free to reach out to us in the Plan Giving office for more information about trusts. Next slide, please. So a charitable gift annuity, how does it work? First, the donor would make a gift of cash, stock, a qualified charitable distribution, or real estate to a charity, and you would receive a fixed payment of income for your lifetime. This can be up to just one life or 2 lives, and those individuals are known as the annuitants. Upon the death of the annuitants, the charity then receives the remaining funds to support the purpose of the donor's choice. This is just limited to the University of Pittsburgh. We do not offer them for UPMC, but you can choose multiple allocations to receive the remaining funds in the annuity. So you could choose, a fund in athletics, a fund in the health sciences, and a fund in the schools and center side. So in the year that you make the donation, you receive a charitable deduction, but not for the full amount of the initial gift, only the estimated amount of the remainder to charity. So the IRS does use actuarial data to estimate the remainder value of the gift. Next slide, please. So if you are concerned about the performance of some of your appreciated assets or need to increase cash flow for yourself or others, please do consider a gift annuity. There are many benefits to them. So CGA works by transferring the cash or securities to the qualified charitable distribution, or apologies, the qualified charitable organization, and depending on your age and needs, you could choose from a current gift annuity, which pays you back immediately, a deferred gift annuity, which begins to pay you at a set time in the future, or a flexible gift annuity, which allows you to decide in the future when to begin taking regular disbursements. The payout percentage is based on your age, so the older you or your designees are, the greater the annual payments. A gift annuity provides other benefits too. There are possible capital gains tax savings if funded with appreciated assets, and a portion of your annual payment could be tax-free. You will have an income tax charitable deduction available to you in the year you create the gift annuity. Excuse me. So each type of annuity comes with its own age-related rules. You must be at least 55 to receive payments from a current or deferred gift annuity, and at least 40 years old to create a deferred gift annuity. Additionally, a minimum gift of $10,000 is required for a charitable gift annuity. Next slide, please. To further illustrate, apologies. To further illustrate, if you donate to the university the sum of $10,000, assuming the age of 70, you are guaranteed to receive $630 per year for the rest of your life. You can fund an annuity with cash or stock, with a portion returning to you as tax-free because it's considered a return of principal. Another portion will be taxed at your ordinary income rate, and if you choose to use stock to fund it, a portion will be taxed as capital gains. You will receive an immediate charitable deduction in the amount of $3,751 in the year you donate the funds. Next slide, please. So in summary, I have compiled an annuity rate chart looking at rates for both single and joint annuitants. As you can see, they have great rates of return, and the rates are evaluated on a regular basis by the American Council for Gift Annuities. Next slide, please. So we are proud to present our Plan Giving Recognition Society, the 1787 Society. It is open for membership for any person who makes a planned gift to the University of Pittsburgh. There are great benefits to this, including a regular luncheon, other events, and periodic updates. We would really look forward to welcoming you to this society. Okay, we are happy to take any questions, and we welcome your feedback.
Awesome. Thank you, everyone. That was really great. First off, thank you to both Shannon and Cindy. As Cindy said, we do have some time left for any questions that come in. We do have a couple as for right now, so we'll get to those. And then if anybody else has any questions, feel free to keep entering them into the Q&A box. So we will just start getting through with the questions. Again, enter them in the Q&A box. You're also welcome to raise your hand if you can't find the Q&A box as well. But first question that we have, and anybody can answer this, but I think this was part of Shannon's segment. At what age should you start to develop an estate plan?
Sure, I'll take that one. I think really, the first time anyone should consider an estate plan is, probably when you get your first job. Like, I mean, I would say even before that, maybe just to have the healthcare power of attorney and financial power of attorney on hand. But really, I mean, when we get our first job, we're starting to think about things like retirement planning. There may be life insurance policies that are offered through employment. So really, I think that's a great time to get in the habit of creating an estate plan. But most certainly, I would say at the very latest, if you either when you're married or have children or own joint property with another person, those are all great times to either revisit or begin estate planning so that you are sure you have all the legal expertise behind those decisions from a tax perspective, and also to make sure that your wishes are carried out. And as we saw with the intestacy statute, it's not always what we think it will be. So we really do want to make sure that our plans mirror what we want in our lives.
That's great. Before we get to the next question, we have a miscellaneous question that came in. Are slides available to guests? Yes, they will be. We also recorded this presentation, so I will be sending a follow-up email later in the week to everyone, so you can review the slides, review the recording, and we'll include any other helpful resources, and you are welcome to reach out to our speakers with any questions that you may have afterwards as well too. The next question that we have, and this one might be more for Cindy, but whoever wants to answer it, what is the most common planned gift that you see?
Yeah, that's a great question. And apologies, I think the dry air was getting to me a bit. So the most common planned gift that we see is a bequest. So a gift through a person's will. That's really the bulk of a lot of the planned gifts that we do see. And we are happy to help with any draft verbiage, to work with your lawyer, anything that we can do to help resource and answer your questions.
I will comment that while bequests are still by far the most common plan gift that we see, in the past, I would say year and a half, we've really seen an increase in charitable gift annuities as well. So they're definitely a very strong number two in terms of popularity, mostly because I think, as Cindy mentioned in the presentation, the rates offered by the American Council on Gift Annuities are very favorable right now, and also the opportunity that Congress has given to make gifts from your IRA, to make charitable gift annuities through gifts from your IRA. For the first time, a lot of donors are taking advantage of those gifts as well.
All right, great. Next question. You recommend every 5 years to update your estate plan. When you do that, do you have to revisit like your lawyer every time, like when you first set it up to establish your plan? So when you renew it, is it kind of the same process to redo that?
It can be. I mean, I think it's a good idea to sit down with an attorney every, 5 years or so. Certainly, if there's any of those major life changes that we mentioned, because that's going to change the terms of your will or trust significantly, and it will require either a codicil or an amendment to a trust in order to change the language within that document. That being said, I mean, I think it's important to sit down because we engage people with legal expertise because we don't know what we don't know. And there can be state laws that have changed, tax laws that have changed that we may not be aware of that might significantly impact our plan. So, oftentimes attorneys, if no changes are needed, it would be a minimal fee, or But again, it always is going to give you that peace of mind that everything is that you want to have happen is reflected within your document, and that you've taken a moment to talk through those situations and make sure that your document is meeting your current needs.
Awesome. Thank you. So right now I'm going to launch a quick poll. If anybody else has any questions, feel free to ask them. But we do just want to get your reviews on this webinar. So for those watching real quick, if you can just select, 1 through 10, 10 being the highest, ranking this webinar, if you would recommend. Thank you for those that are answering already. This is helpful for us. But again, if you have any other questions, feel free to enter those as well. If not, we can wrap up a little bit early. We do have another one through the slides. I will include them in the follow-up email, so you can download them through there, as well as review the recording. So once again, if you don't have any other questions right now and you think of any later on, feel free to, Shannon, Cindy, I can include your emails in the follow-up. So if guests have any questions offline, they can feel free to ask you afterwards as well. So, all right, well, everybody completed our survey. So thank you for that. Thank you everybody for attending, and Cindy and Shannon, thank you once again. I will be in touch with everybody in the upcoming days with the follow-up email. So thank you to you both.
Thank you.
Thank you.
All right. Have a good one, everyone.